All right, good morning. Can everyone hear me?
Yes, Your Honor.
Yes.
All right, perfect. Well, it's 9 a.m., so we're going to go ahead and get started on today's session of oral arguments for the 5th District Court of Appeal. I'm Jamie Grosshands. Also in the panel today is Jay Cohen and Meredith Sasso. Can both attorneys see the clock?
Yes, Your Honor.
Yes, Your Honor.
Perfect. We'll reserve 5 minutes for rebuttal for the appellant. If you wish to have longer, just let us know and we'll adjust that clock. And then if the attorney who is not speaking would mute while they're not, it's not your turn, that would be great. All right, we're going to start then with James Del Holcomb versus State of Florida. That's 18-3338. Appellant, you may begin.
Good morning. May it please the court. Michael Efferman on behalf of the appellant, James Holcomb, and I would like to reserve 5 minutes of my time for rebuttal. I'll focus my time this morning on the first claim raised in the briefs, and I think the claim is pretty straightforward. Mr. Holcomb's argument is that the attorney had an actual conflict of interest, and when the trial court was made aware of that actual conflict of interest, the trial court failed to conduct the required 3-part Lars-Lear inquiry. Now,
let me ask you a couple of questions about that. I'm glad you started with that because I think that is one of the more interesting issues in the case. The conflict was with Hooper and with Angel, correct?
Correct, Your Honor.
And is it your position that simply having represented Holcomb as well as those two individuals, that in and of itself is sufficient to warrant reversal?
My position is that that always amounts to an actual conflict of interest. Simultaneous.
So, all right, and that's what I thought you would say. So let me ask some hypotheticals about that. Let's assume, a couple things. One, I've read the cross-examination of those witnesses, and it seemed to be a very thorough cross-examination, and in fact, really neutralized those witnesses to a large extent and was relied upon in great detail in closing argument. So you've got that factor. And then secondly, the other factor I'd like you to address is, what if the testimony of those witnesses was cumulative to other witnesses' testimony in the case? So if you could address those issues for me.
Yes, and I think my argument for both is with an actual conflict of interest, prejudice does not need to be established. So we can speculate what would have been done on cross-examination. We can speculate regarding the cumulative nature, although again, we don't know in that regard. These were 2 star witnesses for the state who were employees for my client. But we don't go there because the case law says if you have an actual conflict of interest, prejudice is presumed. And I'm going to rely upon the Lee case from the 1st District for a number of points.
All right, but what about Mickens? How would you, you're relying upon a case that was decided prior to a case out of the United States Supreme Court that seems to go a different direction.
I disagree. I think Mickens is distinguishable. Mickens, the victim was dead at the time of the trial. So the conflict had ceased. There was not an active conflict of interest. So in Alexis, the Florida Supreme Court defined an actual conflict of interest as, quote, the active representation of conflicting interest.
So do you not interpret Mickens as establishing an actual adverse effect requirement?
No. Again, in Mickens, the issue is being raised for the first time after the fact. It's not where there's a failure for the trial court upon being made aware of the conflict to fail to follow through with the 3-part Lars-Lear test. And again, Alexis was very clear about that. And Alexis, the Florida Supreme Court said, that test is still required, but only in cases involving actual conflicts of interest, not potential conflicts of interest. And I submit, to answer Judge Cohen's initial question, this is and always is an actual conflict of interest. It can be waived, and it could have been waived in this case had the trial court properly engaged in the Lars-Lear analysis. But absent it being waived, it always amounts to per se reversible error. Mickens is distinguishable. It's being raised for the first time in a post-conviction setting. It's not involving the active representation of conflicting interests. The victim had died at the point of trial. It was obviously a murder charge. And the evidence was that the attorney in that case had only met with the victim the week before the charges in the murder case arose, and had only met for maybe 20 or 30 minutes. But clearly,
Counsel, Mickens specifically states that the proposed rule of automatic reversal when there exists a conflict is rejected by that. And I mean, it says, and we're not going to say there's automatic reversal when there's an actual conflict. There has to be something else. So what in this case are you alleging is more than simply the actual conflict itself?
I disagree with that. I do not believe the case law, and I don't think that's a proper interpretation of Mickens. Mickens ultimately determined that there was no actual conflict, and therefore the defendant was not entitled to relief. It's a federal habeas proceeding as well. There's a different burden that applies in a federal habeas proceeding. Both Alexis, which again is a 2015 case from the Florida Supreme Court, Alexis did not recede from the requirement that when there is an actual conflict of interest in Florida, and the judge is made aware of it, the judge must conduct the three-part Lazalier inquiry. That did not happen in this case. So obviously the state in its answer brief has argued that there was an inquiry early on in the case. And as I've explained in my reply brief, timing matters. At the time of the inquiry in January of 2018, all four individuals were in the same position. They were co-defendants. Two of them had not agreed at that point to testify on behalf of the state. What happened subsequent to that inquiry, and again, I've also argued that the inquiry doesn't even meet the three-part Lazalier standard because the third prong wasn't satisfied. But putting that aside, whatever inquiry occurred in January is irrelevant after the circumstances changed. And this is what the prosecutor herself said. Again, this is the state's argument that I'm parroting on appeal. This is page 66 of the record. The circumstances have now changed. Two of the defendants have entered a plea agreement or have entered their pleas open to the bench and are now witnesses for the state. Circumstances now are much different than they were. There is a greater conflict that exists, one that the state's position is not waivable. Now, I disagree only with that last point. It is waivable if the trial court at that point would have conducted the three-part Lazalier inquiry, and if Mr. Holcomb, having heard the possible conflicts of interest, the fact that other counsel could have been appointed to represent Holland and Angel at that point, and I don't even know how that would necessarily work. There's no way defense counsel in this case could properly represent my client and cross-examine those two witnesses effectively.
Well, that's really the issue. As a matter of policy, I'm not sure that there shouldn't be some sort of actual adverse impact. And this is just my review of the cross-examination was that counsel did an excellent job in the cross-examination of those witnesses, neutralized them to a great extent, and you really cite nothing in your brief to show any actual prejudice or actual adverse impact. And I don't know why, as a matter of policy, there shouldn't be some sort of requirement as opposed to a per se rule.
So that may be, but I submit that based on Alexis, which did not overturn Lee, simply said Lee is limited to a situation that involves an actual conflict. If there is an actual conflict that's brought to the trial court's attention, the trial court is still required to engage in that three-part inquiry. And as far as prejudice, I'll read from the Lee's analysis from the first DCA. This is page 668. The reason appellate courts have declined to apply the harmless error rule to cases in which a defendant was deprived of the right to conflict-free counsel is that any action the lawyer refrained from taking because of the conflict would not be apparent on the record. So, Your Honor, reviewing what occurred during cross-examination, what's going on behind the scene? What did trial counsel in this case know about Angel and Holland that he couldn't properly and effectively cross-examine them?
But that's completely speculative.
But in an actual conflict, that's exactly, so let me go further. They were quoting from Holloway, the US Supreme Court, quote, but in a case of joint representation of conflicting interests, the evil is in what the advocate finds himself compelled to refrain from doing, not only at trial, but also as to possible pretrial plea negotiations and in the sentencing process. So both the first DCA quoting the US Supreme Court said, if there's an actual conflict, prejudice is presumed, because there's no way you could properly evaluate what harm or prejudice there was to the defendant in that situation. So in this case, we know that Holland and Angel had to testify truthfully for the state. If they failed to do so, they weren't going to get the benefit of a favorable plea deal. We also know that when any witness testifies for the state, and in this case, Holland himself brought out that my client was insisting that that he be able to hire their lawyer. It was brought out by the state that my client instructed them not to ask any questions of customers. Certainly, very damaging testimony came out through Holland and Angel. Defense counsel with any.
But that's really cherry picking. I mean, if you read the cross-examination in totality, that cross-examination was, in my view, effective.
Defense counsel in this type of case, anytime there's a state witness, the number one rule of thumb is I need to, if that witness is given testimony that could be deemed credible and harmful to the jury, I need to impeach their credibility. So on the one hand, he has an interest to represent my client, that he not have them appear credible for the jury. On the other hand, in representing both Holland and Angel, he couldn't, I'm sorry, Hooper, I keep saying Holland, it's Hooper and Angel. And representing Hooper and Angel, he could not properly cross-examine or impeach their credibility, because doing so would deprive them of the benefit of their plea deal, because they had to testify truthfully in order to obtain that benefit. And I think the case law is clear that an attorney who cross-examines a client, an attorney who, while representing a defendant, cross-examines a client simultaneously encounters inherent divided loyalties. Certainly we have this in this case. And in Lee, they didn't even question that it was an actual conflict. In Lee, and this is on page 667, in this case, there can be no doubt that Attorney Lovelace and the defendant had an actual conflict of interest. Attorney Lovelace had personally represented a primary witness against the defendant in the past, and his office had also represented the witness about the time he was assisting law enforcement officers in their effort to obtain a confession from the defendant. If in that situation, that's an actual conflict, clearly in this situation, when you represent star state witnesses and the defendant simultaneously in the same trial, that is an actual conflict of interest. I'm not aware of a single case where there has been simultaneous representation of a witness who got on the stand and testified for the state, and the defendant representing, defense counsel representing that witness and the defendant, where that has not been found to be an active conflict of interest. And if it's
in my opening questions to you, I also posed the proposition to you that the testimony of those two witnesses was cumulative of the testimony that other employees and other witnesses gave during the course of the trial. But in your analysis, that would make no difference, correct?
Again, because my points, I guess, are twofold. Point one, it's an actual conflict. Number two, prejudice is presumed, so you don't even engage in the analysis. How was the cross-examination? Is it cumulative? If you were to go there, though, I would say that it's not cumulative from the standpoint that they're the only witnesses who brought out this idea that my client supposedly insisted that they hire a lawyer, or that he be able to hire their lawyer, without a doubt. And the state focused on that in closing arguments. That's something that the state was trying to insinuate, that my client was trying to control them and make it so they couldn't become useful witnesses for the state. Ultimately, they were. But again, that's something that came out, that didn't come out through any other witness. Who knows how that could have been properly attacked had an attorney without an actual conflict or active conflict of interest had properly cross-examined those two. So again, it's not cumulative as far as that point. It's also not cumulative as far as whether or not my client instructed them not to answer any questions or ask any questions of customers. So there's certainly details that came out only through those witnesses that didn't come out through any other witnesses. These were two very unique witnesses, employees of my clients. They were star witnesses for the state. It's clear that the state offered them favorable plea deals so they could get their testimony against my client. So again, the rule I'm asking you to adhere to, and I think it is currently the law in Florida. Alexis is a recent case. It goes through and does a great job of going through all the U.S. Supreme Court and Florida cases dealing with this. But in every one of those cases, they don't involve actual conflicts of interest. Lee was the only one that did, and they in no way said Lee was wrong in making that determination. This is more of an actual conflict than Lee. So, and the only other point I would make, and the state hasn't argued this isn't preserved, but there is a difference when you raise this issue for the first time in post-conviction. The Kyler standard applies, and you have to, and there's also, of course, a difference between just dual representation of co-defendants and actually representing a defendant and a state witness. And I would step back for a second. If I stopped 10 people on the street right now and said, hey, I have a case involving an attorney who represented both the defendant and two of the state star witnesses, everyone would say that's not right. That has to be impermissible. That has to be an actual conflict of interest. That's why in all these cases that are cited, you don't see that. So
Do
we
you,
have,
are you familiar with the Davis versus State case of a third DCA case?
yes, it's cited in Alexis, correct?
Yes. So do you think we need to overlook that reasoning as well? In that case, there was an actual conflict of interest, and the third DCA applied the Mickens standard to determine whether there was an adverse effect.
Dixon is the case I'm familiar with from the third DCA.
Okay. So Davis, again, similar here, similar to the argument here, actual conflict of interest. They cite Lee, but they argue that the Lee kind of per se reversal argument was specifically dismissed by the court, by United States Supreme Court in Mickens, and they go into the adverse consequences. So do you think we would need to certify conflict with the third if we accept your argument?
I think the procedural posture may matter, and I'm not, the state is not cited to that, so I can't respond to that. I apologize. If that's an issue that the court wants me to address, I certainly.
Well, let me ask this. Let's say that we find that argument compelling. Have you argued in your brief, or can you argue now that there was actually a compromised performance in this case, that there was an adverse effect?
That has not been established in this record, and I definitely stick by my position that does not need to be established. If there's and let me phrase it this way then. Alexis came to the Florida Supreme Court after there was a 9.141 petition filed. In Alexis, it was argued that appellate counsel failed to argue on direct appeal that the inquiry that was conducted by the trial court was impermissible. So it was in essence being considered as fundamental error. On direct appeal, you're aware that the trial court is conducting an inquiry, but the trial court didn't conduct a thorough inquiry as required by Lars-Lear. So I think in a situation where it's being raised on direct appeal because the trial court was aware of some type of conflict and didn't conduct the proper inquiry, the remedy that's certainly approved by Alexis is if there's an actual conflict, the failure to conduct that remedy is per se reversible, or conduct that inquiry is per se reversible error. However, if the conflict is only potential, then the trial court doesn't even need to engage in that inquiry. So in this case,
Counsel, you are into your rebuttal. I'm just letting you know.
Thank you. In this case, the trial court was clearly aware because the state itself brought the conflict, which the state actually said was not waivable. It was waivable had the proper inquiry been done, but it was an actual conflict. At that point, the trial court had an obligation to conduct the three-part Lars-Lear inquiry. If you were to rule otherwise, the three-part Lars-Lear inquiry is now meaningless, because it would be a situation where even if the trial court fails to conduct it upon being made aware that it needs to be conducted, the failure to do so would only matter if you could show prejudice. That's not what Florida law currently says. Florida law currently says that if you have an actual, this is Alexis, if you have an actual conflict and the trial court fails to engage in that inquiry, it's per se reversible error, and that's why this case should be reversed. I'll reserve the remainder of my time for
Mr. Offerman, don't you think though it would be dangerous for us to go out and ask people, how we should decide this case in this current context of a pandemic?
That's
Okay.
Good point.
Right.
Good point, Your Honor. Thank you.
Okay. All right. Thank you, sir.
May it please the court, I'm Charlene Matthews on behalf of the state of Florida. First thing I'd like to do is make sure that y'all can hear me okay.
What?
And regarding this issue, there was no actual conflict.
What about the failure to conduct, the inquiry at the point in time when, the two individuals pled? I mean, the prosecutor below effectively begged the trial court to, make an inquiry. Really, he actually didn't even put it more in terms of get new lawyers in. But what about the failure to conduct any type of inquiry at the point in time when the two individuals pled?
Well, Your Honor, this isn't like a forensic inquiry where the law requires the judge to repeat over and over that the defendant understands whatever rights he's willing to waive at that point in time.
Well, but there's a significant difference between representing co-defendants who might not have any conflict. For instance, I mean, you've got the two folks in this case that go to trial, and there's consistent, not inconsistent defenses, and so there's no conflict. But here, once you get individuals who've entered pleas and whose sentences are dependent upon the cooperation and truthful testimony with the state, doesn't that change the dynamic?
I don't think it does, Your Honor, in this case, because Judge Clayton at the very outset went through an exhaustive inquiry for the attorneys. The trial attorney explained to the judge just in great detail how everything, all the facts in this case were an open book to all the defendants. They had all been interviewed repeatedly. The information had been shared with each. I don't believe that there's an actual conflict because it did not adversely affect counsel's performance. And respectfully, we're not here to discuss what best practices is. We're here and y'all are here to decide whether reversible error occurred in this specific case. And because there's no actual conflict, no reversible error occurred.
And so you're defining actual conflict as an adverse effect. So what are you relying on for that definition?
State versus Alexis. An actual conflict of interest is one that adversely affects counsel's performance. And as Judge Cohen explained, the cross-examination of those two witnesses was thorough. Even at the time that this issue came up at the very last minute, it was a suggestion from the trial counsel, just kind of threw out, well, maybe someone else could represent them. There wasn't even a request for a hearing, a request for inquiry. And again, just backing up to what happened throughout the procedural history. Yes, sir.
To raise concerns about it. And if you understand, Mr. Ufferman's response to that would be, well, that goes to show you the problem, that the defense lawyer, just blows it off.
Maybe there was a potential conflict. There's certainly not an actual conflict because appellant has not shown that any conflict adversely affected counsel's performance. That is part of the test. You can't just slide past it and pretend like it's not there. That's the law in Florida. I believe it's federal law as well. And the appellant has not made that showing. Judge Clayton held an exhaustive hearing back and forth between all the defendants. I think for him to have done otherwise would have impinged on Mr. Holcomb's right to have the attorney of his choosing represent him. Everything of record shows that Mr. Holcomb had the attorney of his choosing at the time he went to trial. Regarding the other issues that have not been included in this oral argument, the state would rely on its answer brief and request that you affirm in all respects. Thank you.
Thank you. All right, Mr. Ufferman, I think you have almost 3 minutes, just under 3 minutes remaining.
Thank you, Your Honor. May it please the court. I too am relying upon my definition of actual conflict from Alexis. This is page 937. Quote, an attorney's active representation of conflicting interest is an actual conflict of interest. That's the Florida Supreme Court from just a couple of years ago. I submit that this is like a FREDA inquiry, that when the trial court becomes aware of an actual conflict, Alexis tells us at that point, the trial court is required to engage in the 3-part inquiry. At the time of the January inquiry, there was not an actual conflict. At the time of trial, as the prosecutor argued below, there was an actual conflict, and that's why the trial court had to engage in this inquiry. Pursuant to the state's argument, you would have to show prejudice for the actual conflict that would defeat the entire point of the line of cases that says that the Lars-Lear inquiry must be made, because obviously the Lars-Lear inquiry is going to be made by the judge at the beginning of the process, when the judge becomes aware of the actual conflict, that you're actively representing different interests. At that point, the trial hasn't occurred. You couldn't demonstrate what the prejudice could or could not be. Nevertheless, Florida law requires, and again, this is Alexis, that once the actual conflict exists, the trial court must engage in the three-part inquiry. In this case, it can't be said the trial court wasn't put on notice. It was the state that put the trial court on notice. The trial court's failure to engage in the three-part inquiry in this case, because there was an actual conflict pursuant to the definition in Alexis, means reversal is required. Fundamental error occurred, reversal is required, and that would be the rule. And again, this isn't going to affect too many cases in the future. There's going to be very few cases. Alexis doesn't cite to a single one where a defense attorney actively represented a defendant and state witnesses simultaneously in the same trial. That generally does not occur. That would strike anyone as being improper. Any judge should be on notice of that. Any attorney should have an obligation to bring that matter to the court. But in this case, thank goodness it was the prosecutor who insisted with the judge, you must do this inquiry. If not, there's going to be error in this case. The prosecutor below was right. The state shouldn't be able to change their position now on appeal. The failure to engage in this inquiry was fundamental error. If you rule otherwise, it would mean the Lars-Lear inquiry would become meaningless. You would never be able to demonstrate actual prejudice at that stage of the proceedings. The rule is straightforward. If the judge becomes aware of an actual conflict, the judge must engage in the three-part inquiry. The failure to do so requires reversal. I'd ask this court to reverse for that reason. Thank you.
And you're suggesting that alternatively, you've got per se error, and B, you've got because of the conflict, and you've got per se error because there was no inquiry. Are those two separate arguments?
I believe, yes, I do believe that it's when you show an actual conflict, it's per se reversible error pursuant to Lee. And I also believe that the failure to conduct the three-part inquiry is per se error if there is an actual conflict. If it had only been potential, it would be the result in Alexis. But because it's actual, as defined by Lee, it's per se reversible error. It must be sent back.
All right, thank you.
Thank you.
All right, thank you. Ms. Matthews, thank you.
Thank you. Have a good day.
Thank you.